So this is about what kind of assets must a person have owned when they died to require that a succession take place. So when somebody dies, often they own some assets that must go through the succession process to be transferred, and maybe they also own some other assets that don't have to go through that succession process. So let's go through those two different scenarios. The first type, which is the type of asset that somebody owns that requires a succession for the asset to be transferred. 4 or 5 types of assets. Let's start with real estate. So that one's a no-brainer. If somebody owned real estate in their name when they died, there's going to be a succession necessary to get their name off of the title and get it transferred to the appropriate heirs. And that's the case even if they were married. So let's say husband and wife bought a home together, husband died, husband's succession is going to be necessary. That home, can't be sold by the wife or by anybody else until the husband's succession is complete. His name is taken off of the title and it's put into the names of his heirs. Also, even if someone owns an undivided interest in real estate, sometimes maybe a woman will inherit her parents' house with her 2 siblings, so she only owns 1/3 of the house. Well, if she dies, then her succession is going to be necessary to transfer her 1/3 of the home to her heirs. So real estate, obvious succession asset. Second one is investments. So our securities laws require that the brokerage firms freeze accounts when an account owner dies. So if somebody owns, stocks or bonds, mutual fund shares in their name and they die, those things are going to be frozen, and it's going to take a succession, going to take those court orders that are issued at the end of the succession to be supplied to the transfer agents or brokerage firms in order for those companies to release those shares or release those bonds or release those funds. So investments are another kind of succession asset. Sometimes people own small businesses. They may own them as an LLC or a corporation, and again, the transfer of those when somebody dies has to go through a succession. Others are kind of vague, and now I'll start getting into bank accounts, because I would say by default, bank accounts have to go through a succession when somebody dies. But sometimes, here in Louisiana, we see a lot of parents bringing their adult child to the bank, adding the child on as a signer, or maybe setting up a bank account, POD, payable on death, so the bank will release the funds when the account owner dies. But if a bank account is in one person's name and that person dies and no one else has access to that account's going to be frozen, and the probate again is the only way for the survivors or the heirs to gain access to those funds. So if you have any of those types of assets, and there's other kinds of assets as well, vehicles, but real estate's a big one, investments are a big one. And we'll talk about non-probate investments in a minute. Small business interests is another, and sometimes bank accounts have to go through the probate process. Now, people often own what I call non-probate assets when they die. These are assets that you don't have to go through the judicial system to get those transferred to the appropriate people. The most common ones are things like IRAs, individual retirement accounts, or other retirement plans. Some people have 401ks, some people have 403bs. All those types of retirement accounts you're eligible to designate beneficiaries. So maybe husband died, he had an IRA, named his wife as the beneficiary. He dies, wife can produce his death certificate to the financial institution. They'll move the IRA into her name. No lawyers, no judges, no court orders are needed to transfer an IRA because it passes directly to the beneficiary. Now, sometimes when beneficiaries aren't designated or the estate is designated as the beneficiary, or sometimes by default, if there's no beneficiary, then the funds are payable to the estate, and then it has to run through the court proceeding, run through the court-supervised estate to gain access to those funds. So there's almost exceptions to just about every rule. But retirement accounts, life insurance, where the owner designated a beneficiary, that goes payable directly to the beneficiary outside of probate. Annuities are the same way. Again, sometimes there aren't beneficiaries designated, so the money goes through the estate. Again, requires a succession. Other non-probate assets, I mentioned how bank accounts typically are a succession asset, but sometimes they're not, because the child's on the account, they go get the money, they do it outside of hiring lawyers and going through all of that. So personal effects, those things are non-titled. The gun collection, the coin collection, those things typically aren't titled. So we see a lot of families just, dad dies, kids take care of that stuff themselves. There's no retitling of those assets. So those often kind of pass, under the radar or outside of any formal court proceeding. So just be aware that there's some assets that people own that do require the succession or the court-supervised proceeding to get those transferred if they're in their name when they died. And then there's assets that sometimes don't require that succession proceeding to get those transferred. So that's just the basics on kind of probate versus non-probate assets. Hope that helps. And it can be confusing, so make sure you get all the information you can.